start the call with Senator Roberts, and then I'll come to you, Senator Kovacic.
Thank you, Chair. Thank you for appearing again. Good to see you, Mr Furlong.
You too, Senator.
I have a series of questions for understanding the relationship between awards and Fair Work Commission endorsed and authorised enterprise agreements. Does the Fair Work Commission have a requirement to ensure that pay rates under enterprise agreements are at minimum the same as or higher than pay rates under the appropriate competitive award? So I'll just be specific. If an award requires, say, a cleaner to be paid $30 an hour as a full-time employee, could the Fair Work Commission endorse or authorise an enterprise agreement that paid the same cleaner, say, $25 an hour as a full-time employee?
As we've traversed several times before, Senator, if an application is made to the Commission to approve an enterprise agreement, the Fair Work Act requires the Commission to approve the agreement if it is satisfied that the requirements in sections 186 and 187 of the Fair Work Act have been met. This includes a requirement that the agreement passes the Better Off Overall test. In terms of
which test?
The Better Off Overall test.
Whose test? Yep.
Yeah. In terms of the minimum rate of pay, the agreement cannot provide less than the rate of pay, the base rate of pay in the applicable award. But in terms of penalty rates, it's a holistic view of it. It won't be a case by case basis. It won't be a line by line analysis.
So an enterprise agreement could not pay less than, if it's just a straight enterprise agreement, doesn't roll overtime in and everything else, it could not pay less than the award rate.
Well, in terms of the minimum rate of pay,
yes.
Yes.
Thank you. Okay. There are no tricks in here. I'm just trying to learn. Okay. Do you agree that when calculating a full-time employee rate and adding all entitlements, holidays, etc., allowances, that generally you would add around 19% to the full-time rate?
I can't comment on that, Senator. It's members of the independent statutory office holders, members of the tribunal, who apply the Better Off Overall test and ultimately what they consider and ultimately approve enterprise agreements. I can't talk about what they, in terms of the legislation or the legislative scheme provides the things that they need to consider before approving the enterprise agreement, but it is a case-by-case basis.
So by adding, say, taking that cleaner again on $30 an hour, by adding entitlements of 19% to the effective pay rate, benefit would be around $35.70. So if it's not 19%, what percentage would they use?
I think that what they would do is look at the underpinning modern award and then consider that in the whilst they're considering the enterprise agreement that's in front of them for approval, and then they'll make a determination based on the on those two documents and on the case law, the relevant case law, whether or not it satisfies the Better Off Overall test and the other pre-approval provisions. And on that basis, a member will make a determination if the agreement should be approved and whether or not the agreement should be approved with undertakings.
So there wouldn't be any requirement to pay the cleaner at least, the casual cleaner, at least the award rate plus 19%. There wouldn't be any hard and fast requirement.
There's no hard and fast requirement that, and I understand where we're sort of heading to here. If a modern award does not contain a casual rate of pay, then it doesn't preclude an enterprise agreement containing casual rates of pay.
Say that again.
If the underpinning modern award does not prescribe a casual rate of pay, that does not preclude an enterprise agreement being approved that does contain a casual rate of pay.
How do you think the Fair Work, the Fair Work Commission would assess whether or not the enterprise agreement was not paying less than the award if it was a casual?
In the approval decisions, the members outline their reasons for approving or dismissing applications for enterprise agreements. So in relation to the Chandler and Cloud agreements that I think that we're referring to here, I think it was...
I'm referring to a lot of them, but
yes,
keep going.
Okay. Thank you. The members, including the Senior Deputy President, who approved a number of these agreements outlined the reasons for her decision to approve those instruments, those enterprise agreements at the time. Now,
So,
I can provide copies of those decisions on notice if that would be of assistance.
that would be of assistance. So, the Fair Work Commission, or the member as you call them, so long as she has valid reasons and lays them out in writing, or he, they could approve a casual rate of pay less than the award rate of pay. For the less than a permanent employee rate of pay in the award, a casual rate for a casual could be less than that.
I can't talk to the decisions of members of the Commission. Those decisions stand for themselves, Senator. And whilst I'm trying as hard as I can to be helpful, the decisions of members to approve enterprise agreement, they rest with the member who makes the decision, and obviously the reasons for approving or, as I said, dismissing those applications are outlined in the decisions.
Right. So long as the decisions are justified, that's it.
No, well, there's appeal rights. There's appeal rights. So if an enterprise agreement has been approved and there is an aggrieved party who has standing to have that decision reviewed, then they can certainly do that, and they will be reviewed by a full bench of the Commission.
Okay,
but ultimately, and at the end of if an agreement is past its nominal expiry date, they'll continue to operate until they're replaced or repealed. Then a party or a person who's covered by that enterprise agreement can make an application to the Commission for that industrial instrument to be terminated, at which point they will return to the terms and conditions of the underpinning award.
But excuse me, we'll get to an appeal later, but just for now, an appeal requires going to the court.
In the first instance, it will come back. The appeal will be made to the Fair Work Commission, and then it will be dealt with by a full bench of the Fair Work Commission.
Yeah. So
they'll be constituted generally by 3 members.
Okay. So next question: are you aware of Fair Work Commission endorsed or authorised enterprise agreements that pay employees A, below the base award full-time rate, or B, below the base full-time rate plus entitlements, or below the casual award rate?
I'm not personally aware of instances that are occurring. We approve somewhere between 4,000 and 4,500 enterprise agreements a year, and the process for approving enterprise agreements is the application is made, they are then reviewed by an expert team, specialist team who hold skills and specialist sort of knowledge around the assessment of enterprise agreements. They complete a checklist, and then they will give that checklist and other supporting documentation to the member, and a member will then, with all of that information available to them, will then do a number of things. The agreement will, as made, will appear on our website. So if there's no to invite contradictors. So if there's another party or someone that has reason to believe that the agreement shouldn't be made, then there is an opportunity for that to occur, and that does occur regularly, particularly when there's demarcation issues associated with particular registered organisations, trade unions. But a member could receive submissions or information through that process. They could seek further information from the parties, or they could deal with it on the papers, or they could call the matter on for a hearing if it was particularly complex.
Okay, thank you. If an employer and a union came to the Fair Work Commission with a proposed enterprise agreement that paid below any of the scenarios I've just outlined, is it incumbent on the Fair Work Commission to undertake an independent analysis to ensure that the enterprise agreement rates are above the relevant award? Or does the Fair Work Commission, or can the Fair Work Commission just endorse the enterprise agreement on the basis that the union and employer agree to the underpayment?
The member needs to be satisfied that each of the requirements under the Fair Work Act have been met.
So
So they can do it, to speak plainly, they can do it on the papers if they are satisfied that the information that they have in front of them and the agreement has been supported or endorsed, for want of a better word, by a trade union, then that will obviously carry some weight in their determination about whether or not the agreement should be approved.
I can understand it would. Can I take you to the example of the enterprise agreement between the Shop Workers Union and Coles, excuse me, which was overturned in 2017 after the efforts of lone employee Penny Vickers? Familiar? That enterprise agreement had been endorsed or authorised by the Fair Work Commission and paid Coles employees below requirements. In the face of the employer and union, I'll use the term collusion, certainly agreement, it was efforts of a lone employee, Penny Vickers, against the might of the legal teams of the union and the employer that protected employee rights. One person. So my question is, where a Fair Work Commission authorised endorsed enterprise agreement pays below award rates and both the employer and union have cooperated or colluded on the underpayments, who has the capacity to challenge this? Is it only lone employees, or can someone else, for example like me, mount a challenge to the Fair Work Commission?
That's a very good example, Senator, of when an application is brought by someone who was covered by that enterprise agreement. They brought that application post, I think, I'll have to take that on notice. It's been a while since I've actually looked at that case, the specifics of that case. It's a person, I'll have to take on notice who has standing to make an application to terminate an enterprise agreement. It's certainly someone who's covered by the agreement, or an employer organisation that has representational rights for that employee as well.
So I might not have representational rights if I want to intervene.
I haven't looked at this section of the Act for quite some time, so I'm not too sure who has stand. Does anyone else at the table want this? Might have to take it on notice.
Okay, thank you. Two more questions, Chair.
Sure.
If the Fair Work Commission authorised or endorsed an enterprise agreement that paid employees less than award rates, could this arguably be a case of the Fair Work Commission engaging in maladministration or some other error of law? Are there processes within the structure of the Fair Work Commission that such a review of underpaying enterprise agreements can be undertaken?
Do you mind if you just repeat the first part of the question, please?
If the Fair Work Commission authorised or endorsed an enterprise agreement that paid employees less than award rates, could this arguably be a case of the Fair Work Commission engaging in maladministration or some other error of law? And are there processes within the structure of the Fair Work Commission that such a review of underpaying enterprise agreements can be undertaken?
Just return to my early evidence that if someone believes that a decision of the agreement is a decision of the Commission has been made in error, then there are those appeal rights, and they should exercise those rights.
Would it arguably be a case, if Fair Work Commission overturned its original ruling, would it arguably be a case of the Fair Work Commission in the first ruling engaging in maladministration?
I can't. The independent statutory office holders exercising powers provided to them under the Fair Work Act. It doesn't relate to the administration of public servants. So I just want to return you to my evidence that the correct mechanism for dealing with this would be through an application for the agreement approval decision to be reviewed and overturned.
Right. If it was found that the Fair Work Commission didn't apply the right, didn't consider the right factors in making it, in approving or authorising the enterprise agreement, would that be maladministration?
Do you mind if I take that question on notice, please, Senator?
Yeah, sure. Yeah. Last question. You are aware of my interest in black coal miners and the One Nation report that sets out in forensic detail how casual mine employees are underpaid in comparison to the award. I assume you're aware that the Fair Work Ombudsman is investigating the underpayments.
Yes.
You're aware of that. If the Fair Work Ombudsman were to conclude that coal miners have been and are being underpaid in comparison to the award, are there processes whereby such underpayments could be stopped and historical underpayments could be addressed by the Fair Work Commission with a view to compensating coal employees for the underpayments they suffered?
My understanding of the evidence that's provided by the Fair Work Ombudsman earlier this evening is that the reference instrument that they're relying on for their calculations to determine if there's been an underpayment is the enterprise agreement, not the underpinning award.
But come back to my question. If they're being underpaid in comparison to the award, if that was found, if that was the reference document, then could the Fair Work Commission address that by compensating coal miners?
I think that the relevant... I'm not aware of the Fair Work Ombudsman actually doing the calculations against the award, because that's not the industrial instrument that applies to the employment of these coal miners, the casual coal miners that you're referring to. So my understanding, I obviously can't speak on behalf of the Ombudsman, I can only relay my understanding of their evidence from earlier this evening, is that the assessment won't be against the MON award, it will be against the enterprise agreement that was approved, or the enterprise agreements that were approved at whatever point in time.
Okay. Thank you very much. Thanks, Chair.
Thanks.